Assalamualaikum warahmatullahi wabarakatuh. Generally, I want to say that the past case between the Maria Costa Gonzalez and the Google Corporation indicate that the protection happened when the Spain Protection Agency requests Google Corporation to delete all the particular information of the plaintiff, which is Maria Gonzalez, since he wanted or he requests the Google to do so. This crisis leave a huge impact on social media, and some of the citizens come up with opinion and their thought regarding the case and issue. As media users, I can say that Google was an established company that have been operate to organize the world information and make them available for the people access. But according to the past case and scenario, I believe that everyone got right and freedom to be forgotten. It was unethical for Google or internet to remove particular information of people without the personal agreement. However, it is essential for Google to remove the particular information when the people by themselves agree or requested to do so. Personally, based on observation and my research, I believe that people and users were basically independent and free from any discrimination or political unfairness. To me, people can request for data removal by internet since it can lead to several difficulties and damage to particular person or organisation, such as the third parties. For example, the GDPR stated that all website users must learn and notified about how the data was collected and being interpreted by the website or the digital application. It was very crucial and important for everyone, including the internet users, to learn more regarding their right and concern regarding their personal data collection. Otherwise, it was unlawful to keep analyzing privacy information when the consumer refused to do so. For example, nowadays most websites will give some notification and pop-ups asking users to consent for cookies. In advance, in certain cases, it also liable for people to claim for loss and correction when the data are mistake caused by the website or the search engine for privacy and information data. The online users nowadays can send a request or complaint to the Google Incorporation to remove the unwanted data related to themselves for privacy and protection purpose. For example, the case between Maria Costa Gonzalez versus Google Spain during 2012, it indicate the human right protection from damage by any commercial organisation. The Court of Justice of European Union held that the search engine were responsible to carry out personal information appear on the web page which are public by any parties. Finally, now we can learn that Google also facilitate a medium for all the internet users to learn more regarding the data privacy and setting. They have served a medium for personal content, product policies and removal requirement. The system also helpful to display particular information, policy and further action that can be taken by the consumer and the internet users. Nowadays, global communities can gain wide access to this server since they can achieve and complete this action to the Google search engine. Besides, all users also can give a feedback and question in the report a problem section that provided in the help center. That's all from me. Thank you.
Hello everyone, my name is Divya Ganesan with metric number 278157 and I'm going to present about question 2, which is how does public policy with respect to individual privacy differ in United States and Europe, and what explanation this difference? Actually, the public policies governing individuals' privacy differ significantly between United States and Europe. Actually, the difference between the United States and Europe are based on historical, culture, legal and physiology consideration. So, one of the most significant difference between these two countries is their legal frameworks. Actually, the United States regulation privacy using a sector-specific approach with different laws covering different sectors and characteristics of data. Furthermore, cultural perspectives are one of the different parts where public policies differ in US, which is United States, and Europe in relation to individual privacy. The United States economical and interest and also individual freedom are frequently given attention in privacy regulations. Another area where public policy about individual privacy varies in US and Europe is government surveillance. The United States has encounters discussion and legal dispute around government monitoring particular aspects of the regulations. Next, corporate accountability is an additional dominant where public legislation and also another part of logistic differ between the United States and also Europe, which bring a impact on their countries. So that's all from me. Thank you.
Hello, my name is Chong Wei Fai and my metric number is 277099. I will continue with question number 3. In what ways has technology made it more difficult for individuals to protect their privacy? Firstly, tracking and collecting data. Technology, especially search engines like Google, creates a lasting digital footprint. Advanced tracking technology like cookies, device identifier, and cross-platform tracking method collect a lot of data all of the time, such as our location, browsing history, and what we buy. This information is collecting invisibly in the background, and users usually do not even know how much data is being collected. Secondly, data breaches and cybersecurity. When technology getting advanced, cyber criminals also getting better to hack others' information without any permission. People do not have much thought over the security measure used by the site and company that handle their data. Thirdly, user consent and control. Google, like many other technology companies, gets a lot of information about its user in order to make its service better, make them feel more like what they are using them, and show them more relevant advertisement. By this way, users will agree with the permission, and unfortunately, this takes away their power over their personal information. Lastly, complex data ecosystem. Individuals or users are difficult to control their personal information because the data is connected to so many complicated ways across the platform. Even already deleted from a Google site, but copies of the deleted information may still exist others' digital ecosystem. That's all from my part. Thank you.
Good day everyone, my name is Win Kamei, numbermetric 278817. I will present for the question 4. The criteria that used by the Google in modifying individual search result is that the first one, legality. Legality is the legal requirements such as the data privacy and collection requirements, cookies requirements, copyright and plagiarism requirements, and others. These laws are to provide a user with the right to know and control their personal data if being collected, sold, and shared. Individual requests are generally not accommodated to be modified unless they violate to the Google policy. The second one is accuracy and relevance. Google is established to organize the world information and make it universally. So an accuracy data is essential for Google to meet its objective. The company needs to keep the data up to date to ensure the user get the latest information. The third one is Google will be modified based on the user experience. Google that will do some level of personalization based on the user behavior, search history, and preference. User can influence their search experience through setting to filter the explicit content from search result. However, there will have the limitation. Legal compliance is one of the limitations that the company must be compliant with the applicable law and regulation regarding user privacy, data protection, and content removal. Legal constraints will affect the company to modify or remove the search result. Next is implementing individual search result modification can have a technical challenge. The Google has worldwide information that distribute to the user. Due to this, some of them may be entirely within Google control. So they will have the technical challenge for the Google. That's all for question 4. I'll pass to the next presenter.
Good day to doctor and everyone. My name is Tan Ke Sing, metric number 280653. So, based on question 5, if I am a Google executive, how would I balance the individual privacy right with the public interest to know and the right to distribute information? First, I need to make sure Google always comply with applicable law to balance the individual privacy right with the public interest. I need to control and make sure there is a distinct boundary between information that should be made public and information that should not be made public. For example, the information such as sensitive personal information, exploitative image or video, or any other negative content of an individual should not be made public as it will cause harm to an individual. So, second point, Google should encourage transparency in data practice. This means Google should only collect and use information for specific purpose. For example, when users sign in its Google account, Google will collect information to understand user preference so that Google can provide better service to its user. Other than that, Google should have well-defined privacy policy to provide a clear sense of data practice for the user so that they can understand and agree on the objective related to the shared data. So we moving on to the third point. The privacy policy should be reviewed and enhanced regularly. So Google need to collaborate with international regulatory body to make sure Google have follow local privacy law and keep updated with the latest privacy law. Besides, Google should establish a strong precautionary system to prevent any unauthorized access to users' data, for example, encryption, safe data storage procedure, and monitoring for any possible security risk. And lastly, Google should emphasize anonymization and data aggregation when sharing information for the public. By this way, Google is able to safeguard the privacy of an individual and at the same time provide useful information for public. And although the public has the legal right to know some information, but Google still need to consider the necessity to share information, whether that information will violate the privacy right of an individual by using the utilitarian approach. So that's all from our group. Thank you.